So my first question is, looking at expert witnesses and the role of experts, do we still need experts with the rise of adjudication, alternative dispute resolution, the desire to reduce costs and the cost of dispute resolution? Can you see a time when expert witnesses and experts might become redundant? Have we had enough of experts?
The short answer, Stuart, is no, and that's not just a natural bias and a hope for myself who practices as an expert, but the fact is that lay people have assisted the courts in reaching their decisions for a very, very long time. And our own Justice O'Flaherty put it here that experts should be the servants of justice. And so without experts to offer their opinions to judges on matters that they probably do not understand, there's a real risk that decisions might be reached where a judge either misunderstands the issue or forms an opinion on a matter that is contradictory maybe to the prevailing norms in a professional practitioner's experience. And I think that the rules of the courts are worthy of enough, where expert evidence shall be restricted to that which is reasonably required to enable the court to determine. I think the operative word is enable, and that really is the purpose of experts. And it still remains true that the courts require the assistance of men and women of science to assist them in the administration of justice. So quickly turning to ADR, and if we think about the world of adjudication, and once I often heard that one of the much touted advantages of adjudication is that you have a person deciding your issues who is familiar and indeed may well be an expert in those issues, whether they are the technical, the legal, programming or quantum issues. So the question is asked, why appoint an expert to assist the expert adjudicator themselves? And then my own experience is that due to the nature of adjudication, the experts can be of great assistance to the adjudicator, much more so than some might expect, because an adjudicator is granted extremely wide powers in ascertaining the facts and the law and the procedure that they wish to actually process the adjudication with. However, they are granted very little, if any, time compared to arbitration of the courts. And in matters of detailed delay analysis, technical analysis, quantum analysis, they may not have the time to do the detailed work, and they may well be very happy to receive a well-presented and coherent expert evidence, which does a degree of that analysis for them and allows them to focus on the determination of the factual and liability issues. And if the adjudicator considers that the expert evidence carries sufficient weight, they can choose the preferred periods of delay or the preferred quantum sums from the expert's evidence. It also allows them to avoid the very dreaded pitfall of descending into the arena and performing their own delay analysis or quantum assessment, where they don't allow the parties to make representations on how the adjudicator actually goes about that analysis. That it results inevitably in challenges for breaches of natural justice. So I think that's how it sits in the adjudication world, very useful for issues that require it. And again, that idea of enabling justice to be done. On mediation, just a recent experience of mine that it was very short-sighted of the opposing side to dispense with their quantum expert, because when the mediator comes back into your room and relays what the other side has conceded or not on, the party and the mediator needs to know what the commercial and quantum calculations of those issues might be. They need to know it quite swiftly and accurately, and all of a sudden the QS becomes a very useful person to the mediator and the parties in those circumstances. So again, my answer is no. I think the role of the experts will be around for some time to come.
Brilliant. That's really interesting, actually. I'd not come across that view on mediation before. So moving on, I think we'll move on to George. So John, if you can pop yourself on mute again. And George, so one of the things that comes up occasionally with experts, and I've heard it when I've been working with them in the past, and we're assuming for the purposes of this exercise that most people on the call are familiar with the role of an expert and what they do and who they are. But so in court, how do you deal with advocacy that catches you unawares? And have you got any particular experiences of people cross-examining or catching you out in ways that you hadn't expected?
Thank you. Stuart, and delighted to be taking part in this panel. I'm also very pleased that you asked me that question because I was prepared for it. I was half wondering whether you would throw in a question that I wasn't prepared for, just to demonstrate live what it can be like. So I think in terms of unexpected questions that catches you unawares, first point I would make, and it may seem an obvious one, is that avoidance of the situation to the extent possible is the best solution. And by avoidance, I mean, obviously the golden rule is to prepare thoroughly. Because if you sit down with your legal team as an expert, if you sit down with your legal team and prepare and think through what are the sorts of questions that could be raised, you can often foresee the sorts of points that might be raised. For example, it might be a particular point, a previous case that you've been involved with that appears on your CV, or an article that you wrote, and you, if you think these issues through, there are things that you can foresee and then plan for. And obviously that's the point, is not to be caught off guard. Having said that, of course, although you can statistically, if you like, reduce the chances of being caught unawares, you're not going to eliminate it. There will always be questions that could come up that you simply won't have thought of, and they could be raised. It could be to cause distraction, or it could be to cause you to become flustered. And of course, these questions, they can fall into different categories. They can, for example, you might be asked a question that is something that is outside your area of expertise, and if that's the case, then just say so. Just be open about it. I remember on more than one occasion I've been asked questions where it went into a technical area. So, for example, something from an engineering perspective rather than a quantum or quantity surveying perspective, which is my area of expertise. And also, I've been asked questions where it went into a contractual area, where it was again something where I couldn't venture an opinion. But that was in connection with an arbitration in another country, where maybe they were less familiar with the specific area of expertise, as a quantum analyst. So the rule here, the golden rule here, is just don't be tempted to stray into an area that's not within your expertise. Just say so and be open about it. Right. Of course, you may have an unexpected question that's off the wall, that you've not thought of, and you can't actually see the relevance of the question. But again, it's best to answer the question that's put to you, not to enter into an argument over the relevance of the question. And certainly in my experience, there are times when I've said that in passing, I've said, well, I'm not sure how this is connected to the matter, but my answer is ... So, as I say, there are times when it might be something you may not understand the relevance of it, but if it's in your area of expertise, just still go on and answer it. And then, of course, it may be something which is a question that's raised that is within your area of expertise, but it's a very complicated question and it requires a lot of thought. And again, my advice would be, as an expert, is be straightforward and say whether you need some time to properly consider a thought-through answer. And there have been occasions where I've experienced where a tribunal has been willing to take an answer from me after a break or after a reasonable pause. And in any event, if you are pressed nevertheless to give an answer, then at least if you still have doubts about it, if it's something where there are a lot of issues and you're under the pressure of time, then state what your reservations are and don't try to sound overly incisive. If it's something where you still have doubts about it under the pressure of time, then say what those doubts are and then express your view over the range of answers you have. And then the final point I was going to say is that if it's something in your past, if it's a previous case or something, maybe an article you published or something in your CV, again, the first point is be prepared. Try and foresee what these points are that could be raised. And And if it's a question where somebody is, the question's being raised as this is something where you gave evidence or you wrote an article and it seems inconsistent with what you're saying, then explain the specifics, why it is that your position on this current case rightly differs, that it depends on the facts. I'd say also just try to remain calm and open. Don't sound evasive. And if you do feel under stress, try not to let it knock you. Don't keep going over it in your mind, so that when the hearing goes on, it's sometimes easy to be thinking, oh, that didn't go well, but you've just got to forget about it and move on, because in all probability, it wasn't such a serious issue and in the judge's or tribunal's eyes. So I think that covers the main points I was going to make. Brilliant. But obviously, if you want to follow up, please do.
No, thank you. That's great. Yeah, it's particularly interesting, the point about articles that you've written in the past. Certainly from our perspective, so our role in life is to help experts and consultants and other people to write articles and to do the knowledge sharing and marketing piece. And obviously, quite a lot of the time we come up against resistance from people saying, "Oh, we can't possibly say anything on that subject in case we got cross-examined on it in the next case that comes up." So, yeah, it's interesting to hear that perspective on how to deal with those things. So, I'll move on to Eammon. So, obviously, Eammon's got the sitting on the other side of the fence as an instructing solicitor. I guess I've got questions got kind of two aspects to it. How do you find a good expert witness, and also, Eammon, what checks do you put in place to ensure that experts don't let you down?
Thanks, George. I'll come to that question, but I just, listening to the question you asked, George, I had a bit of a war story or an anecdote to that I think illustrates by way of an example. I had a program, a time expert in a case where it was an arbitration, and it was, as often happens in construction arbitration, where the experts on both sides gave evidence, not in this case in a hot tub, but one right after the other. I was for the respondent, and the claimant's expert brought up a point which he said was an error that my expert had made, that had not been raised, not been mentioned in his report, and had not been mentioned in the quite extensive consultations the experts had had with each other, conferences the experts had had with each other. So during a break, I asked my expert about it, and he said, yes, that was quite right. He had made that mistake, and he was going to correct it. So I was a bit worried about this, of course, and thought about it a bit and started to get a bit less worried. But when my expert was then sworn, and when he was asked to say, was this his report and was it correct? He said, no, it's actually not. In paragraph 4.2, I said such and such, and what I said was wrong, and it should be stricken from the report. Now, actually, that actually, not only did that not have any adverse effect, because the point was one that he was able to deal with and wasn't significant in the overall scheme of things, but actually gave him, as far as I was concerned, and I think as far as the tribunal was concerned, a great deal of credibility. And it was, I was impressed with the fact that this expert had the confidence and the calmness to just say that right away and to completely diffuse the point. So it's an example. It's one of the ways in which I saw an unexpected point, not a point of advocacy, but something was unexpected that came at the last moment, actually came from the opposing expert's evidence. So in terms of how do you locate a good expert for a particular case? I mean, the short answer to that is using all the resources available to you. But I would probably break that down into two broad categories, and maybe a few more, but broadly two categories of experts. There are the experts who are accustomed to giving evidence, and then there are those that are not. And in terms of the types of experts who are accustomed to giving evidence, examples are the programming and quantum experts that, like we've been talking about. like the two experts we have on this panel. There are a few other categories that fall within that. People who give evidence on standard of care in negligence cases, or on custom and practice in trade of a trade, and also evidence of foreign law. I would put all those in sort of one category, and say that when I would be looking for an expert in one of those areas, it's quite likely I would go to someone I know. And if it's not someone I know, it's someone that I would have consulted with a colleague or with a few colleagues, and would have had good experience with. Quite likely someone I've worked with before. But there are cases where either because of of relations with clients, in cases of public procurement, I've had situations in acting for public bodies where there has been a requirement to actually run a competition to appoint an expert. In just looking in terms of those types of experts, in my view, quite a lot of the work that is done by quantum experts and programming experts, it certainly does include expert evidence in the sort of strict legal sense, expert opinion evidence on areas like valuation and method of measurement. But a lot of what guys like John and George do, I would say, is broader than giving expert opinion. It's probably could be called preparing demonstrative evidence, summarizing quantum, the same in relation to program, to delay analysis. It's taking an overview of evidence and summarizing evidence in a way that's helpful to the tribunal and perhaps necessary. But it's a little bit, it goes beyond what, from a sort of lawyer's standpoint, you would see as traditionally expert opinion evidence. And a really important part of that, and one that I think is often underestimated, is writing a good report. I mean, I think the written part of expert evidence is really important, and perhaps as important as being able to defend an opinion in cross-examination, and largely because reports are what's still there when a hearing has concluded, and of course most cases settle, and expert evidence, a well-written report that's clear and understandable, is what will communicate and make a position clear. So that's that category of experts. The other category, I would say, are the ones who give evidence on very specialized areas like metallurgy or paint chemistry or ultrasonic testing of welds or electrical loads applied to transformers. And those are just some examples of the types of experts that I've dealt with. And very often those experts are difficult to find. And in there, I would, if I needed an expert in an area that I didn't have, I would expect that my client, who is in that area, to have quite a lot of to have contacts. I would speak to colleagues, I would speak to organizations, and try to assemble as much information as possible. And sometimes there are literally only a few people in the world who are experts in a particular field, and in that case, sometimes those experts may not be accustomed to giving evidence, may not have given evidence ever or frequently. Where they have given evidence before, even if it's in a different part of the world, I would always try to talk to the lawyers who had instructed them, and maybe the lawyers on the other side, to get an impression as to their as to how they did, and that's part of the way you find out what you can about the expert. Yes, of course, you would look for what they had written. You can do. I would speak to colleagues. I would search the person's name on Bailey. I know that's not popular with experts, but the reality is that many judges have, and particularly in the English TCC, provide their own views on the evidence that experts have given, and that is sometimes given in quite trenchant views. And if I find that I carefully considered Mr. Taft's view, he was very convincing, and of course, the more convincing the judge is saying the person was, it's starting to not look good. And he says, but on this particular case, I preferred Mr. Delaney's view. I don't mind that at all, as so much as where the expert has been criticised for not having fairly considered the issues, not having addressed the issues, and those are, I think, the mortal sins. It's not so much the expert's opinion that matters; it's the reasons that are given. And when I talk about a report, what I would look for in an expert is the ability to explain their opinions. How you stop them from letting you down or try to avoid them letting you down. You can really be let down in two ways by an expert. One is where the expert has a view that's not helpful to your case. It's certainly my job to find that out as early as possible. If I've consulted an expert and they have a view that's not helpful to my case, I need to take that into account, and my client will need to take that into account. That's pretty important, particularly if it's a view that's expressed by an expert that I have trusted enough to ask for their opinion. But nonetheless, you find that out at an early stage, and then decide whether you need a different expert. The other way, and probably what the question is aiming at, is where an expert lets you down because they don't give a good account, they don't give a good explanation. Or indeed come across in a way that appears partisan. You really need to, as a lawyer instructing an expert, you really need to do your homework. Either, hopefully you'll have prior experience of the expert. If you don't have prior experience, you've spoken to people who have, you've seen what they've written, and in that way you'll be able to put your trust in experts and in the expectation that they will, once they go into that box, that when of course you lose all control and contact, that they do their best.
Brilliant. Okay, that's really helpful. Thank you very much, Eammon. So I'm going to move on to Sarah. So the next question that I'm going to move to is one that Sarah's one of Sarah's former colleagues, Nick Child, said, just ask the first part of this question, don't worry about the second part of it. What irritates a counsel when working with experts? So what causes the biggest problems and challenges when you're cross-examining, or whether they're on your side or you're cross-examining the other side? What are the biggest issues that you come across when working with experts, Sarah?
Thanks very much, Stuart. A great opportunity for me to rant about experts. So the first thing, and I think that's been covered to an extent by the earlier comments, first thing is writing a poor report. That is, I think, the single worst thing an expert can do. If the report is incomprehensible, badly paragraphed, with multiple appendices, some of which are only available electronically via a link which only stays live for 7 days and you've missed, and which is far too long. So what are the top tips for writing a good report? I've got about 6. The first one, shortish, is good. You're not looking to write War and Peace as an expert. Tribunals are human and they get bored. So shortish is good, is the first point. Second point, this sounds very picky, but can you paragraph number it properly? I think one of my biggest bugbears is report numbering that goes 10.1.2.1b subparagraph 1, and paragraph numbers are not carried through to the following page, so you have to guess whether it's 10 that you start with. What about starting numbering reports just 1, 2, 3, 4 in a conventional way? Third point for report writing, executive summaries can, in my view, be a bit of a nightmare. Now, I accept that they are like Marmite. I love Marmite, but I hate executive summaries, particularly if you have an executive summary at the beginning and a conclusion at the end, and they don't say the same thing. If you have to have an executive summary, make it clear, short, and relevant to what you talk about later. Fourth top tip for writing a report: do not put the main content of your report in an appendix. Appendices are for supporting information, not for your primary views. And again, remember, the tribunal is human. They want to find out your views quickly and easily. Fifth top tip: writing proper sentences that make sense. Again, that sounds very rude and an unnecessary thing to say, but it's surprising how often sections of draft reports that we're asked to look at simply don't make sense. And finally, and again, very basic, deal with the issues in a logical order, have some clear headings, plan where you're going, start at the beginning and carry on until you get to the end. So that's writing a good report. And I absolutely agree with George, I think it was, who said how important that is. So it might have been Eammon, actually. The second real problem area for experts is changing your mind at a very late stage. If you have a view that is that is contrary to the client's case, of course that's fine. Of course it's fine. And you're right in your view, I'm sure. But tell us sooner rather than later. When I first started out as a barrister, someone much senior than me told me a story about a case they were doing where the issue was there heave? And this barrister had had countless conferences with the expert, question constantly asked, is there any heave? No, no, no. Then first question at trial in cross-examination, is there any heave? Yes. There's not much that you can do as the barrister or indeed the solicitor at that point. And when I was told that story, I just laughed and I thought it was just a story. It would never happen to me. Until, of course, it did happen to me in relation to dry rot. Again, conference after conference with our expert, and we asked and asked and asked whether the surveyor should have spotted dry rot, and the answer was always no, until cross-examination when suddenly the answer was yes. And of course, it's too late in the middle of the trial to be able to sort that problem out. The next problem, it's not only writing a good report, but it's writing a good report yourself. So it is really a big problem if you don't, as an expert, write your report, or if, as of course is very often necessary, you need help with writing the report because it's so lengthy and detailed, you must know the report. An expert is putting his or her views on the line at a trial or arbitration or other dispute resolution forum. So either an expert has to write the report or they have to know it back to front. It's an absolute gift to a cross-examiner. If you're asking a question in cross-examination, please turn to Appendix X, and the expert sits there, looks completely blank and says, oh, well, I didn't write that appendix. You're not going to be supporting your client's case very much if that happens. What else can be very irritating as an expert? Getting caught out in cross-examination. Now, of course, that can happen. The other side can just have a point they've kept up their sleeve, but there are some things that I think are avoidable and should be avoided. First of all, think through everything beforehand. Secondly, listen to the questions that you're asked. Again, that sounds stupid, but listen to the questions very carefully in cross-examination because there may be more to questions than you sometimes think. And even more important, listen to the questions in re-examination that your own barrister asks you, because those questions are often designed to sort out whatever mess may have occurred in cross-examination. Then read your report and know it back to front. If you do that beforehand, you shouldn't get caught out in cross-examination. And then don't try to be too clever. Don't lose your temper. Don't argue. Don't refuse to answer the question. Again, absolutely basic points, but we've all seen some inexperienced experts who get caught out there. What else is a real problem? It's obviously straying into advocacy, and that's been touched on already. It's very difficult. I think it's particularly difficult if you're a delay expert to separate your expertise from the facts, but I think it has to be done. So you've got to make it clear, both in the written material and in cross-examination, that you're expressing views on matters of expertise. Don't stray into commenting on the documents, the witness statements, or the facts. other than in order to express your view. And it may be necessary sometimes to offer your view on two alternative views of the facts. So as an expert, it looks partisan if there are two alternative views of the facts and your views are only based on one of those views. It may be necessary to take both alternatives and express a view on both of them. I think that's probably all I was going to say on the most irritating things about experts, but I could carry on all day, I expect.
Thank you. Okay, that's great. I forgot to say earlier that if anybody has any questions, do put them into the chat box in the bottom right-hand corner, and we can ask the questions at the end. And we are now approaching the end. So thank you to our speakers. I have one more question that I'll just put out to anybody that wants to answer it, really. So there has been an argument, apparently, and I hadn't heard this until yesterday when it came up in discussion with the speakers, but that judges have been, obviously there have been some very well publicized cases where judges have been quite critical of experts and their role and their evidence. And so some experts have argued that hearings should only take place in arbitration, so that they're the rather acerbic decisions that are written about them don't get put into the public domain. Do any of our speakers have any thoughts on that particular view from the from certain experts?
I think it was a point that I raised actually yesterday when we were discussing this. It is obviously, if you're in the public domain and you're criticised as an expert, it is potentially a nightmare and can damage your prospects in future cases. But I think rather than saying you don't want to give evidence in court and the problem is that judges are very unfair, the important thing to do is to take all the steps that we've been talking about today and make absolutely sure that you do know your report, it is well written, you don't stray into the arena and start taking partisan points. And then hopefully a judge will not express any negative views about you. And in fact, the reverse may well be true. The judge will say how very impressive your evidence was, and that will improve your prospects of being re-instructed in future. So that's my view on that point.
Excellent. And any of the other speakers have any views on that sort of thing? I think John might be about, are you about to lean forward and turn the microphone on?
Thank you, quickly, Stuart. I think from a public policy point of view, it would go against the grain, and the grain has been very long established for experts to give their opinion and their evidence in private. Public courts are public courts by their very nature. If you're in that particular realm, you put yourself forward as a servant of justice, as I mentioned earlier, and you're there to perform a role. It's up to you to actually perform it, irrespective of if the judges are deemed to be harsh or not. I haven't been on the receiving end of a harsh judge, so maybe my view is rather tainted by that fact. However, arbitration is private. The parties are privy to it. The parties' representatives are privy to it, and it stays very much within the arbitral community, which, to some respects, anecdotally, people might say that allows the use of partisan experts to be much more common in the world of arbitration.
Right, thank you.
I would just say it is, I think, a bit of a disadvantage of the privacy of arbitration, that it sometimes allows all sorts of carry on, not just by experts, but by lawyers and perhaps witnesses, which, because of the lack of accountability that goes with it happening in public, and we just have to, it does put pressure on the tribunal to be aware of that and to deal with it, but it doesn't have the accountability from case to case, and that either, as Sarah says, either in a good way or a bad way. Most of us, I'm sure all of us on this panel, would think that our reputation would be enhanced by the way we conduct ourselves in cases, rather than detracted from.
Great, thank you. Okay, well, there are no questions in the question panel, so I will, for now, leave it at that, because I know I'm very conscious that we try and keep these things as brief so that we don't interrupt everybody's working day too much. So we'll draw a discreet veil over it at that point. One thing thought I might mention is if anybody out there is not an expert witness at the moment and is looking to become an expert witness, and I'm being told that my internet connection is unstable, so hopefully you can hear all this. But if you're looking to become an expert witness, a former colleague of mine, Jeff Whitfield, has written a book on So You Want to Become an Expert Witness, which may be of interest. If you Google Jeff Whitfield, Jeff, and Whitfield is WHIT Field, you'll find that book on the internet and available to, and I'm not on commission, so I hope he'll give me a cup of tea or something next time I see him for mentioning that. But it looks like quite a good read. I think it's a kind of collection of his various blogs, and he's a good writer, so so that's worth a look. Next time we do one of these Construction Cast events, we will hopefully be looking, I think, at procurement, possibly procurement arguments. So if we're lucky, we might even persuade Sarah to come back for another session, because that's her real specialist field. And bidding to win. So we're going to have a bidding specialist as well in to join us for a session. He's really good if we can get him. So do join us in 2 weeks if you can. And otherwise, thank you all very much for tuning in, and we'll see you very soon. Cheers. Bye-bye.
Bye-bye.
Thank you.